practice of law? You can either put it in the chat or say it out loud. But the faster we go through these, the more questions we can get through tonight. What is not the unauthorized practice of law?
A.
That is correct. A broker is representing the buyer, a buyer. A buyer expresses an interest in a property that is advertised in the paper for sale by owner. The broker calls the seller and asks to show the property to the buyer. When must the consumer guide to agency relationships be given to the seller? I see some C's and some D's.
Yeah, I think it's C or D. I think probably D. That sounds more important.
So I got 2 D's, 1 C, and that is incorrect. It is A.
Right.
So during their telephone conversation, the broker must disclose to the seller the fact that he represents the buyer. So always think initial contact, first substantial contact. So first substantive, I guess is how they call it. But first substantial contact is when the relationship must be disclosed. So it's during their phone call. The sales agent is interested in buying some property. The sales agent walks through a seller's house but does not mention being a sales agent. What is true?
B.
Say B.
I think so. Like the sales agent is not allowed to buy property. B. Yeah.
So the first answer, they have not violated any laws. So you only have to make the announcement when an offer is made. So just walking through doesn't violate any laws. So only when an offer is made, if they're on the buying side. If they're on the selling side, they have to disclose it right away. In any advertisement, anything like that. But on the buyer side, it's only once you're making an offer that you'd have to disclose that. The sales agent represents a seller in a listing. What are the agent's duties to the customer, the buyer?
C.
That is correct. A broker lists a home. This agreement can be terminated by all of the following except.
Maybe the salesperson. Yeah.
Yep. Salesperson is actually not part of the contract. Even though they may sign on that agreement, they're signing on behalf of the broker. The sales agent is taking a buyer through a home. The sales agent has not viewed the basement. When asked about the condition of the basement, the sales agent says that the basement is completely dry. What is true?
Misrepresentation. C.
Correct. What duties are owed to a third party involved in a real estate transaction? You just had this question.
Yay. First one.
A licensed sales agent is contemplating selling her own property. What must the sales agent do to comply with Ohio law?
What is FSBO?
For sale by owner.
Oh, okay, got you. A.
We have agreement on A. That is correct. Who is not an agent or sub-agent?
C.
Correct. The sales agent is found guilty of violation of the Ohio Revised Code involving non-disclosure of an agency relationship. What is a liability of the sales agent?
A. Wait, maybe. D.
That is correct. A fine not to exceed $2,500. A buyer signs an agreement with a broker under which the broker agrees to represent the buyer in dealing with third parties. What did the buyer sign? Correct. So a purchaser agency agreement would be the same as a buyer agency agreement. A buyer signs an agreement to purchase a home. The seller has not provided a property disclosure form. When the buyer requests the property disclosure form, the seller refuses to provide it. What rights are available to the buyer? What do you all think? What rights are available to the buyer if there's no property disclosure? All right, I got a D in there. And that is correct. The buyer may rescind the contract. The sales agent advertises a property for $180,000 when in fact the sales agent has listed the property for $200,000. The sales agent does not have the seller's permission to advertise the property for $180,000. What statement is true?
C.
Correct. Agent Bill has had a busy open house. In fact, 3 buyers want to make offers on the property and have asked Agent Bill to be their agent and are willing to consent to dual agency. What documents must be given to each of Agent Bill's new buyer clients?
Um, I want to say D.
B as in boy, D as in dog.
D as in dog.
That would be correct.
Nice.
So, consumer got the agency disclosure statement, and a contemporaneous offer disclosure, letting them know that multiple parties are making offers. All right. What is not a fiduciary duty of an Ohio real estate licensee?
B. Lord. B.
Correct. A broker takes a listing on a property. The sellers state that if necessary, they are willing to accept an offer of $5,000 less than the listing price. What is the obligation of the broker to the buyer?
D.
What is it?
D. As in dog.
That is correct. Salesperson A knew that Mr. and Mrs. Buyer were working with salesperson B under an exclusive purchaser agreement. Before A can work with the buyers, he anybody? Before A can work with the buyers, he
I think it's either B or D.
so in multiple choice you have to choose one. At least in this multiple choice.
Right. You know, work with buyers until the. I'm gonna go with D. Feels better.
Is in dog?
D as in dog. Should
I don't see anybody in the chats. There are several of you in here.
say B and D.
So it's B. So ask the B's broker when the agreement expires and wait until it does before contacting the buyers. A buyer asks a sales agent to prepare a land installment contract. The sales agent goes to the local legal publishing mart and purchases a pre-printed land installment contract form. The sales agent proceeds to fill out the pre-printed form. What is true?
C. A.
A. So it is the unauthorized practice law because the pre-printed installment contract, it can't be like it can't be written out on a land installment contract. It has to be a party to the transaction. So they can only complete a sales contract form. You can't do a pre-printed land installment contract form. So sales contract form is different than that because the land installment contract is an agreement to purchase the property over a period of time. It's seller financing essentially. And so the sales agent cannot fill that out because it has to be a party to the transaction.
Got it. That makes sense.
A real estate agent is selling Ohio property that is owned by a resident of Indiana. The buyer is a resident of Florida. The real estate agent must be licensed in
Ohio. They're selling it in Ohio.
That is correct. Wherever the property is, they have to be licensed wherever the sale is happening. A real estate licensee owes the fiduciary duty of confidentiality to the seller until
C.
you say C. Did I hear C? I see C in the chat.
Yeah, C.
All right. There is one caveat to that. When can you break confidentiality?
Court order?
Court, if a court orders you to.
Right. If you're under subpoena, if it's court ordered. So that is the only time. All right. So that was brokerage relationships. Let's finish out the state portion and do license laws. So 30 of the 40 questions are going to be in these two categories. When a broker does not wish a salesperson to continue with this company, the broker
B.
Anyone else? Let me see what the chat says. I got B and I got a C.
C.
That is correct. Send a letter within 3 days of sending the license back. A broker and seller agree verbally that the broker will assist the seller in finding a buyer. The broker then finds a buyer for the seller, but the seller refuses to pay the broker a commission. What statement is true?
The seller must pay the commission?
I think it might be B, because it says verbally. It's not in writing.
Oh,
Maybe.
So I got D.
Sales
And
agent must
then
be the
what
seller.
else?
Maybe actually they could sue. Well, I think I'm gonna go with B though because it's not in writing. Well,
I'm gonna go with D.
D?
Yes.
All right. You all would be incorrect.
wow.
They cannot recover it. It's verbal. Listing has to be in writing.
I just said
So, that's the thing. If it's a verbal agreement, it's, there's nothing they can do. You can't prove that necessarily. So because it was not in writing, the broker is out of luck and is owed no money. A broker advised the salesperson not to take a listing because the seller did not want anyone to know about a hidden defect in the house. What must the salesperson do?
B.
B?
Yeah. B. Yes.
B.
That is correct. The seller gave her agent a check for getting her house sold so quickly. What must the salesperson do with the check?
C.
Give it to the broker.
Correct. At what point must earnest money be deposited into the broker's trust account?
D. Immediately.
Within 48 hours.
All right, I got a couple D's. I got within 48 hours.
Oh wait, no.
And I got an A. Way
An
to
A.
go. Way to
Oh,
go,
yeah,
A.
that's-
A.
That is it.
According to the terms of the contract. So the contract will take precedent. It could say that the earnest money must be given to the seller. It's whatever the contract states is where the money goes. The rate of commission that may be charged on the sale of improved property is what?
B.
Good job. Remember, anytime you talk about commission or fixing commissions or setting commissions or making a standard price, it is Sherman Antitrust. You're violating the Sherman Antitrust Act. Broker X is managing a client's 5-unit apartment complex. The broker receives rent deposits of $100 for each unit. What must the broker do with the rent deposit receipts?
D.
B.
For the last one. The last one.
This D?
Yes.
C?
I say B.
All right. Let's see. All right, everybody's saying B. So remember, these are receipts, and so that would be correct. Deposited in the property management's account in the client's name. Buyers make an offer to purchase property and to place $1,000 in earnest money into their broker's trust account. The sellers want the earnest money check made payable to them instead. The sales agent should
C.
C.
That is correct. A salesperson asked that the broker return her license to the Division of Real Estate so she may transfer to a new broker. The sales agent makes the request in a certified letter, but after 10 days, the broker has not mailed the license to the division. What is true?
B.
B.
That is true. B. Broker could lose their license. What law requires a broker's license to be placed in close proximity to the federal fair housing poster?
C.
That is correct. Ohio licensing law. Under what condition can an assistant talk with a client about the terms of an offer?
C.
If she have a C.
Correct. They have to have a license. Real estate recovery funds claims are limited to what dollar amount?
40,000.
40.
40,000. Yeah.
Correct. A closing occurred on September 30th, 2012. under Ohio licensing law, the soonest the broker can dispose of the file is
B,
15.
correct. 3 years. What language does state statute require in a listing agreement?
B.
B, no, C.
C is correct. Blockbusting. So it has to have a statement about blockbusting. You all know the difference between blockbusting, steering, and redlining?
Steering is when you're trying to make them go to another neighborhood, right?
Mm-hmm. So an easy way to remember this: steering is buyers, blockbusting is sellers, and redlining is loans, lending.
Okay.
So steering has to do with buyers, blockbusting has to do with sellers, and redlining has to do with loans. It's an easy way to remember. A broker receives an earnest money payment. The broker deposits the earnest money in his trust account. By law, what is the amount of interest a broker may bear on this trust account?
0.
0%.
Correct. You're only allowed to bear interest on property management accounts. What protected group is covered under the Ohio Civil Rights Law, but not under the federal Civil Rights Law?
Ancestry.
Ancestry.
That is correct. A seller and broker agree upon a listing that would pay the broker a 6% commission if the broker finds a ready, willing, and able buyer for the seller's home. The broker finds a buyer who meets the seller's terms, but the seller refuses to pay the broker's commission. What remedy can the broker pursue?
B.
C.
Say B as in boy.
C.
C.
C in trouble.
That is correct. Sue the seller. When advertising a listing, a broker offers buyers a $2,000 carpet allowance. What statement is true?
The last one.
No.
A.
Yeah. It's A or C.
Probably that.
It's A. So as long as they disclose it in the purchase contract, it is legal.
Okay.
Yeah, it's only unlawful if it's not disclosed. What lien automatically attaches to a commercial property to secure a broker's commission?
The broker lien?
Yep.
Yeah, I was going to say that should be pretty easy. And remember, broker liens are only in commercial. They don't apply in residential. An auditor appointed by the Ohio Superintendent's Office asked to review a broker's records. What must the broker make available?
C.
C.
Yep. All right. So again, 30 of your 40 questions on the state are those two categories: brokerage relationships and license laws and Ohio Real Estate Commission. Rules of the Ohio Real Estate Commission. Now, the majority of your national portion are going to be on these 4 categories: general principles of agency, practice of real estate, contracts, and financing. 55 of the 80 questions will be in these categories. Many states have imposed the canons of ethics, and the Board of Realtors promulgated the Code of Ethics in order to
B.
B.
which law mandates how much a real estate broker can charge for a commission?
B.
The state.
I gave you this one earlier. Anytime you talk about standardizing a commission or making a commission the same across the board, you're violating Sherman Antitrust Act. So there are no such laws. There's no standard commission. No mandates on what a commission should be. A couple walks into a sales agent's office looking to buy a new home. The sales agent perceives the couple to be of a certain religious background. The agent shows them property only in areas of town with a high concentration of the same religion. The sales agent is guilty of
Steering.
Steering.
There you go, buyers. That's right, steering. When a buyer asks an agent what form of co-ownership they and their spouse should take, the agent should
D.
say D as in dog.
Yep.
That is correct.
Mhm.
Not make a recommendation. Agent Sarah goes to a listing appointment and convinces the seller to agree to a commission of 7%, as this is the broker's customary rate of commission. The seller asks Sarah if she would offer 4% to the buyer's broker. Sarah should
Get the broker's permission.
Yeah.
That is correct. So the listing agent, it works on behalf of the broker. So the agreement is between the broker and the seller. So always get the broker's permission. An exception to the federal fair housing law is discrimination based on
B.
C. An exception. C.
That's right, economic considerations. So if you don't have money to purchase the house, you can be discriminated against. Licensee is working with the buyer as a customer. The buyer has the agent write an offer. When must the agent give a copy of the offer to the buyer?
As soon as it's signed.
Yep.
B.
That's correct. Which could a real estate agent lawfully prepare?
C.
Yep.
Correct. The Civil Rights Act of 1866 established which as a protected class?
C.
Yep.
The sales agent solicits homeowners to list their property by suggesting a wave of minorities is moving into the neighborhood. The salesperson is guilty of
B.
A.
right.
No.
No, it's blockbusting.
Oh.
Remember, these are sellers.
All right.
Blockbusting is sellers, steering is buyers, and redlining are loans. The seller signs a listing agreement with a broker. The broker designates the salesperson to service the listing. While promoting the new listing to the other salespeople at the office, The salesperson tells the group to bring in any offer. The seller is very motivated and is in a hurry to sell. The salesperson would be allowed to say this when the
C or D?
when the seller instructs them to. That's the only time you're allowed to say that kind of thing is if it's under the seller's instructions. An illegal act that encourages homeowners to sell their property because minorities are moving into the neighborhood is called
Blockbusting.
Blockbuster.
right. An illegal same question. A real estate agent owes a professional responsibility to the public to
C.
Yeah.
which type of contract could a real estate agent lawfully create from scratch?
A.
No.
None.
An individual comes into a brokerage office looking to buy a new home. A sales agent greets them at the front door. Because the individual seems to be of Asian descent, the agent automatically refers them to another agent in the office who is of Asian descent. This could be construed as
Staring.
Staring.
All right, we're going to go to general principles. That's the other big category. An attorney in fact is best described as
B.
A.
everyone agree with B?
No, A. I say A.
A is correct. So, an attorney in fact receives authority under a power of attorney, and they don't have to be an attorney at law. One who acts or has the power to act for another is termed the
A.
correct agent. The person authorized to act in place of someone else in legal manners is called a
Power of attorney.
B.
Oh,
B. B or C.
B.
All right, I'm just looking at the chat. And that is correct. We just went over that. So an attorney in fact. A person authorized to act on behalf of another is called a
Agent.
It's like they really want you to know this. A sales agent is selling his own personal home, the condition of which he misrepresents. The agent is sued and raises the defense that he was not acting as an agent in this sale, but was selling his own property personally. The probable outcome of the case is the
C.
That is correct. Remember, you are a real estate agent 24 hours a day, 7 days a week, 365 days a year. There's never a time where you can represent real estate and not be a real estate agent. An agency relationship created through a listing contract can be terminated by the
A.
Mhm.
Correct. A relationship between one person, the principal, and another, the agent, wherein the agent is given the right to act on behalf of the principal in a business setting is usually called
B.
Agency relationship.
Mm.
which is the best example of a general agent?
Property manager.
Yeah.
That is correct. During a 90-day listing agreement, the seller dies. Which statement is true?
The listing is terminated.
Mm-hmm.
Correct. An agent is one who
C.
correct. All right. Ran through that one. All right, let's see. So we did general principles. Let's do contracts. A commercial broker listed a storefront for rent. A tenant was procured. After the lease was signed, the owner refused to pay the listing broker in order to obtain their fee. The broker could
Sue, sue for the specific performance.
So this one is a little different because remember this is commercial property, so they can put a
Oh,
broker
yeah.
lien on it.
Okay.
So commercial property, they put a broker lien on the property.
And that's only with commercial, right?
Only with commercial can you put a broker lien on it. A seller signs an exclusive agency agreement with a broker. The day after the listing is signed, the seller's brother-in-law decides to make an offer on the property. Without knowing that the property has been listed, which statement is true?
A.
Is it A? Everybody agree with A? Awfully quiet in here. So I'll give you a hint. What kind of agreement was signed?
Exclusive agency.
Agency. Oh, no commission.
Oh, exclusive.
No
So what does
commission.
that mean?
Broker is not a C.
That is correct. The broker is not entitled to a commission. It is not an exclusive right to sell. It is an exclusive agency agreement. So if the seller were to find their own buyer, then they owe the broker nothing. The seller signs an exclusive right to sell listing agreement with a broker. However, the seller's brother-in-law makes an offer on the property the next day, not realizing it is placed in a listing. Which statement is true?
A.
Yeah.
Sorry.
Correct, because that is an exclusive right to sell. Someone asked the question, what's the difference between an attorney in fact and power of attorney? So power of attorney is the thing that gives you the right to do it. Attorney in fact is actually doing it, being it. So one is giving you the right to do it. It's a power of attorney, gives you the power to do it. The other one is you actually doing it. Does that make sense? It's a semantics difference of one being the act of it, the other one being the power of it.
Yeah, that makes sense. Thanks.
Okay. Mary buys Sally's property, which is subject to a mortgage. After 5 years of payment, Mary defaults and misses a payment. Which is the appropriate remedy for the original mortgagor? What do you all think?
A.
Everybody else agree? Because it's wrong. They have no recourse since there was no assumption. So remember, mortgagee and mortgagor. Sally is the mortgagor. So the mortgagee is the bank. So when you say which is the appropriate remedy for the original mortgagor, you're talking about Sally. So she has no recourse. So whatever happens, happens to Sally. So since Sally remains totally liable on that mortgage. So just always pay attention to the wording. Mortgagee versus mortgagor. The bank is the mortgagee. The buyer is the mortgagor. John and Mary are getting a divorce. John tells Mary that unless she agrees to sell their home immediately and split the proceeds, he will institute legal proceedings to gain custody of the children. If she agrees, the sales contract may then be voidable because of
Rest.
correct. Adam and Jenny enter into an agreement wherein Adam will buy Jenny's house at the asking price of Jenny will install a new roof. And if Adam can qualify for a loan sufficient to cover the purchase, until the roof is installed and the financing obtained, the contract is said to be
D.
Yeah.
that is correct. An option
D.
Did you say B or D?
D is in dog.
Yeah, D.
That is incorrect. So remember the option, when you do an option, it's a unilateral agreement. So you're saying that, it requires the optionor to complete the purchase if the optionee so elects. So that's how that works. So it's only a unilateral agreement. Only one person has to do the deal. So if the buyer, the optionee, says, "Hey, I want to do this," then the optionor, the seller, would be obligated to do it. But the buyer can always say, "No, I'm not interested anymore," and no one's obligated. So it's a unilateral agreement. In a face-to-face meeting, a farmer offers to pay a roofer $1,500 to install a roof on their barn. The roofer says, "I'll do it tomorrow." Which type of contract do they have?
Express.
What's that?
Express, or maybe voidable. I want that express.
Express. So express just means it's verbal, that it's been expressed in words. A lender qualifies a new borrower who signs a note and mortgage. Then the same terms of the note and mortgage are transferred to a new mortgagor, relieving the original mortgagor of liability. This is known as
C.
you say C?
Yeah.
That is correct. An option agreement is a,
Just talk about this.
well, we just talked about this.
A.
There we go.
Oh, A.
Unilateral contract. Who is authorized to rescind a voidable contract?
B.
You say C.
B as in boy.
B as in boy. Any other suggestions on this one?
That makes me feel it's like it's not right. So maybe it's
Any other suggestions?
only the minor. That's the answer.
So a voidable contract can only be rescinded by the injured party. So either party is not correct. The agent and the seller only is not correct. A minor would not be able, if a minor is in a contract, then it becomes voidable because it's a contract with a minor. So remember, it's only the injured party can rescind the contract. So
Are they saying minor as an injured party or like an actual
well, a
minor?
minor is never held accountable in a real estate contract, and they're what's known, they don't have contractual capacity.
Mm-hmm.
So that's why they're always able to void a contract if a minor is involved, because they would be considered the injured party because they would be taken advantage of, so to speak, because they're a minor. Now, if a minor is not involved, then it would only be the injured party in the agreement of whatever made the contract voidable. So in this situation, the minor was the only option available that was correct. It doesn't mean that only a minor can void a contract, though. It's just that in that situation, the minor was the only option that was available that was correct. A seller signs a listing agreement that commences today and ends on December 31st of this year. The listing agent tries as hard as possible, but simply cannot find a buyer who is interested in the property. After the first of the year, the listing is terminated by
Expiration.
correct. A contract is entered into on fraudulent terms introduced by the seller. Upon discovery of the fraud by the buyer, the contract would be
Undiscovered. Voidable by the buyer.
correct. Injured party. So, if upon a receipt of purchase under certain terms, the seller makes a counteroffer, the prospective purchaser is
Relieved from the original offer.
Mm-hmm.
correct. Melissa went to the dry cleaner and dropped off her good wool coat to be cleaned. When the clerk accepted the coat, Melissa and the dry cleaning operation had just entered into which type of contract?
Implied.
Why?
Correct. So it's not put into words, it's an understanding that, you know, that it's implied on what's going to happen. All right. We're not going to have time to go through another one. And that was pretty good. We got through all of, you know, the national stuff as far as brokerage relationships and license law. We did contracts, we did general principles of agency, and also the practice of real estate. The only one we had left was financing, as far as the major categories that you would face in your real estate exam. So, any questions for me?
Yes, I just have a question. Could you repeat what's on the state and national, please?
Yeah, so 55 of your 80 questions on the national are going to be about the two biggest categories are practice of real estate and general principles of agency. So those are going to have the most questions. Then you're going to have contracts and financing right behind them. So those four categories are going to be 55 of the 80 questions that you're going to see on the test. Okay. And on the state portion, 30 of the 40 questions are going to have to do with license law and rules of the Ohio Real Estate Commission and brokerage relationships. So the majority of your questions are these two categories. So study these really well and study these four really well up here, and you should have no issue on your test.
Okay, thank you.
Well, thank you all for joining.